5 seconds to go. Start. Only in such a case, an option is available to opt for the either old pension scheme and GPF scheme or CPF scheme. Stop. There is a difference between appointing a contract employee on a regular basis and regularizing the services of the contract employees. Stop. Moreover, when the bylaws were framed, the regularization rules were not in existence. Stop. In this case, we are dealing with the regularization of the service of the contract employee in terms of the regularization rules and not an appointment on a regular basis. Stop. Respondent number 1 has been regularized under regularization rules. Stop. Therefore, clause A4 of bylaw 52 will not apply to respondent number 1 whose employment has been regularized under the regularization rules. Stop. Para. As noted earlier, Rule 6 clearly lays down that those who are regularized under the said rules will not be entitled to benefit of any scheme other than the new pension scheme. Stop. Even when the exception carved out to Rule 6 is applicable, it enables the regularized employee to continue with either CPF or the old pension scheme as per the option already exercised by him. Stop. The regularization rules under which the employment of respondent number 1 was regularized do not permit the regularized employee to change his or her option from CPF to the old pension scheme. Stop. Clause 52 of the bylaws cannot override subsequent statutory rules in the form of the recruitment rules. Stop. The recruitment rules are made for giving effect to the resolution of the General Executive Council made on 18th February 2009 for the regularization of the academic staff appointed on a contract basis. Stop. After having taken benefits of the regularization rules, the entitlement of respondent number 1 will be governed by Rule 6 and not by Clause A4 of Bylaw 52 of the bylaws. Stop. Para. The tribunal, as well as the High Court, have proceeded on an erroneous basis that after regularization, respondent number 1 was entitled to change his option from CPF to the old pension scheme in terms of Bylaw 52. Stop. The High Court erroneously observed that regularization would relate back to the date of initial appointment made in the year 2002 when the order of regularization dated 4th May 2012 expressly states that the regularization will operate from the date of the said order. Stop. The High Court came to the conclusion that in view of the second proviso to subclause A4 of Bylaw 52 of the bylaws, on the failure to communicate the option in the prescribed manner, it shall be deemed that the employee has opted for the old pension scheme and GPF. Stop. Subclause A4 of Bylaw 52, as observed earlier, will not apply to an employee whose service has been regularized under the regularization rules. Stop. In the present case, in view of the provisions of the regularization rules, there was no question of making available such an option. Stop. Para. In the circumstances, we find it difficult to sustain the impugned judgments. Stop. It appears that respondent number 1 has returned the benefits received by him under the CPF scheme. Stop. As a consequence of setting aside the impugned order, we direct the appellant to pay the amount to which respondent number 1 was entitled to under CPF. Stop.